today's webinar, Managing Your Affiliates and Partners in the Financial Industry, we'll be discussing online compliance, best practices, and brand protection techniques you can apply immediately to your financial services business. I'd like to go ahead and introduce our speaker for today's presentation. We are joined by partner compliance expert, Daniel Morton. Dan is a product marketing manager for MarkMonitor. During the past 5 years, he has focused on a wide range of issues, including affiliate and partner compliance, online traffic diversion, trademark and search engine policy abuse and pay-per-click advertising, social media brand abuse, and online celebrity impersonation. In his current role, Dan helps communicate details of MarkMonitor brand protection internally and externally with a special focus on topics related to partner compliance and pay-per-click advertising abuse. So with that, I'll go ahead and turn things over to Dan to get us started.
All right. Thanks, Gina. Hello, everyone. I'm Daniel Morton, Product Marketing Manager here at MarkMonitor. So today I want to take you through the often confusing world of financial compliance, specifically as it applies to your independent dealers, brokers, agents, and franchisees online. So I'll talk about some of the areas where non-compliant partners might be slipping through the cracks and exposing your company to a variety of different types of risk. Specifically, that risk around regulatory agencies that might come down hard on your company and slap you with fines or punitive measures. But before I get started talking about privacy policies, advertising disclosures, I want to put out there a disclosure of my own. At MarkMonitor, we're not financial compliance experts, and we don't pretend to be. What we are experts at finding abuse online. So in the context of this webinar, we're going to be looking at abuse as your independent agents and brokers operating outside the rules and guidelines that you've set up for them. Those would be established most likely by your compliance team. So we'll do a high-level overview, like a 10,000-foot view of those areas. Then I'll talk about how to design a partner compliance program so you don't have those non-compliant partners slipping through the cracks. All right? So with that, let's get started. So this is our agenda for today. Part one, we'll look at different financial regulations. I'll go through a number of different regulations that apply to your online world as it relates to your partners. And then I've got some examples of corrective action that some of the government agencies have taken. And then part two will be designing a robust program that involves the different areas of visibility, education, and enforcement. So let's jump in here. So when I first saw this graph, I thought it looked like spaghetti, dry spaghetti before you put it in the water. This is kind of from the U.S. Department of Accountability Office, the GAO, and it shows the relationship between the different government agencies and the different industries. This is as a result of Dodd-Frank, which created a lot of different oversights. It actually created some multiple government agencies having responsibility for the different industries, so it created some confusion there. And then also there's the if you see the CFPB, which is the Consumer Financial Protection Bureau, they're responsible for enforcing a lot of these rules that all of these government agencies have put out. So it's very confusing to the layperson. And when you have all of these government regulations, I put this slide up here just because I thought it was interesting. If you look at, in 1975, 71,000 pages of code of federal regulations, and then today you have 178,000 pages of federal regulations. That's a huge increase. That other number there, that 1900%, is the increase in budget allocated to U.S. regulatory agencies. And so these are all those boxes that were across the top in the last slide where, they're going out there, they're looking for different types of abuse, whether it's online or offline, and they're, slapping companies with fines and punitive damages. So that is the gist of this presentation today, is how you can create a program that avoids a lot of those areas and stays on top of the government regulators and avoids those fines. So I pulled this from the SEC. This is what we call the Associated Persons Rule. And I'm not going to read it, but essentially, paraphrasing it, that broker-dealers must supervise the activities of their personnel. So regardless of whether they're employees, independent contractors, third-party, independent agents or brokers, they're responsible for their agents. And so if you look at it from the point of view of a parent company, all of your entities that are out there operating on your behalf, you're responsible for. And I know this is from the SEC, so it's more securities focused, but there's a lot of areas that fall under there. And then when you look at different industries such as insurance, they have similar types of rules in place. So today, this is what we're going to be looking at. We're going to be looking at these different areas of focus: privacy statements, disclosures, endorsements, advertising, social media, spam, and then I threw in a bonus here of copyright trademark misuse. So if you were to kind of bundle these up, essentially what we're talking about is marketing practices and consumer communication as they relate to your independent brokers, dealers, and franchisees. I'm going to take the 10,000-foot view on these. If you have a compliance team, your compliance team is going to be intimately aware of these different regulations. What I'm going to do is just kind of relate them back to what your brokers and dealers that are operating independently may be putting out there, and maybe some areas of risk that you might be seeing. So the first one is privacy statements. So you see these all the time, right? You see these when you go onto websites, and there's a reason for that, because data breaches have been happening, and privacy is a hot topic right now. It's a big thing. And so, the government, with its Gramm-Leach-Bailey Act, has, put out some guidelines on what a privacy statement should look like. It needs to be clear, conspicuous, and accurate. It needs to be reasonably understandable. And it needs to be designed to call attention to the significance of the information. And so if you have a link that is buried on page 3 of your website, that's not really going to cut it. In fact, it needs to be on the home page of your website, and it needs to be hyperlinked from other pages as well. And I just pulled this example. It's a little bit hard to read, but essentially those arrows or those pluses allow you to open up the different areas, and it talks through the different areas that are important, including privacy around social media, protecting children online, security of your data. So if you don't have a privacy statement, that's very robust, I mean, you could be opening yourself up to some risk there. But putting that aside, if you're talking about the parent company, most likely your corporation, you have a privacy statement, and it's probably pretty airtight. Where you might be getting into trouble or could open yourself up to some risk is if your different various independent brokers with their own websites don't have a privacy statement in place. And so that's really kind of where, from our perspective, you need to be aware. And so that's one point of compliance that you should be looking at. The next one is disclosures. So these are essentially texts that say what, you've made a statement somewhere, and a disclosure is essentially, giving more detail about that statement, right? And so it needs to be, whenever there's advertising involved, it needs to be close to that triggered claim. So if you're making a claim about something, for example, if you're talking about something in the real estate market and you're making a claim about interest rates or payment information or different fees, no fee, that sort of thing, you need to have your disclosures right there and right available as much as you can. the law does say that you can use hyperlinks, but they must be clearly labeled. And it also says you need to repeat disclosures as necessary. At the bottom of this slide, I have this source. It's put out by the FTC. It's a really good reference. It's a .com disclosures, how to make effective disclosures in digital advertising. So that's worth checking out. It kind of goes through a lot of different examples. How do you do disclosures in social media? How do you do disclosures on a mobile website? Again, when you're talking about your third-party brokers and agents, if they're out there making claims and they're not putting disclosures, there's your risk right there. So specific industries also have specific disclosure requirements for individuals. If they're on social media, for example, the insurance industry, they want to make sure that you have your full name and insurance company, perhaps the location of your principal office, the list of states where insurers insured, and some states even want the license number. And then the mortgage industry has some other requirements. And again, I'll pull up my disclosure from the beginning in that I'm not a compliance expert, but what I can reference is the fact that if your brokers and agents don't have whatever it is that's required for your industry, and they're out there putting things on websites or social media, and they don't have that, that is where you're going to be opening yourself up for risk. Okay, endorsements and testimonials. So everybody wants to use testimonials. They're a form of social proof. They help other customers make decisions. You've seen the ads, or not the ads, but the reviews on Amazon and those types of things. And companies that are trying to sell a product want to use testimonials whenever possible. But since the financial industry is a heavily regulated industry, there's a lot of different burdens placed on how you can use those testimonials or endorsements. Just some things that kind of came out of this FTC guide, they have to be honest. They have to reflect the findings and experience of the user, which kind of goes, in a way, it's a little bit common sense to me. An interesting one here is they can't represent something that would be deceptive if made by the advertiser. So if, for example, the parent brand, if it were making the same claim that you're claiming that a customer or in a testimonial was making, and it would be deceptive, then you can't use that. And then the other big one, especially when you're talking about reviewers and things on like blogs and affiliates, they need to disclose if any compensation has been provided. And then you have the insurance industry, and I just threw this out here as an example. There's a lot of additional burdens placed on the insurance industry when it comes to testimonials and disclosures, especially around life insurance. So if you're in a particular industry, you're going to know, or at least hopefully your compliance team will know kind of what you can say around those or how you can use disclosures. It's something that if you're looking at your third parties, you definitely need to keep an eye on how they're using those disclosures. So advertising. I put this up here just because advertising is kind of a broad word, and the government regulators have come back to say, any commercial message in any medium that is designed to attract public attention or patronage to a product or business. So that includes, obviously, your website, but you may not think of your home page of your website as an advertisement, but it is. Your social media posts, obviously, those, fall under, they can fall under the commercial message portion of this. There's another side of that would be transactional messages, which don't have the same requirements. But when it comes to advertising, it's a very broad statement. And so you have these different requirements. I put this up here. These are from the real estate industry, and you have requirements for these different logos to be placed on any advertisements. And it comes from the days when you had print advertisements. but it now relates to when you have online advertisements. So your website needs to have these logos on it if you're in this industry. There's not a lot of leeway for, let's say a mortgage broker that has an independent site and isn't putting up the correct logos and disclaimers and that sort of thing. So that's something to keep your eye on. I wanted to talk specifically about kind of deceptive practices, because this is really the heart of what the CFPB is looking for, is any kind of deceptive practices. Now, those deceptive practices might not be considered deceptive by your independent brokers or dealers. It's in a way, it's up to the regulators to determine if they see those as deceptive. And there's a number of different examples, which I'll show in a little bit, that talk about actions that companies have taken that the CFPB is deemed as being deceptive and have slapped them with, $1 million fines. And so I just pulled these from the mortgage industry, and obviously if you're in a different industry, there's going to be other examples. But one of the biggest ones is misrepresentation of government affiliation. So this is where you might say you're associated with a certain government program, maybe one designed for helping low-income housing or that sort of thing. Whatever it is, if you're claiming that you're part of a government program and you're not, obviously that's deceptive. In doing some of the research for this webinar, I came across some examples of offline deceptive practices, which I chose to exclude because we're mostly focused on online, but I'm sure everybody has gotten those postcards in the mail that look like it's come from a federal government agency and talks about, your home loan and how you can, refinance or this because it's this government program. That's straight up deceptive, and the government has come down hard on a lot of companies that do that. So, the point here is not to go through every deceptive example, but to just talk about the fact that if you have your network of agents out there and they're even on the line, that's something that you'll want to be aware of and then make a business decision whether that is something that they should be doing or saying. Because this is an area that's really a hot button for the government and the CFPB in particular. Let's talk a little bit about social media here. So it's uncharted territory still, for the most part. When you have a lot of the rules and regs that were written, back before the internet, or at least before, widespread use of social media sites, it comes into question, is a, Facebook post, for example, is it an advertisement? Is it a customer communication? Where does it fall? And if it is an advertisement, then it needs to abide by the rules around advertising. So the FTC is a little bit ahead, so that's kind of more the banking side. They're a bit ahead of, let's say, the insurance side when it comes to issuing guidance. I pulled this from the FDIC, Social Media Consumer Compliance Risk Management Guidance. And they offer up the advice of the four main things that you need to have. So, from their language, a financial institution should have a risk management program that allows it to identify, measure, monitor, and control the risks associated with social media. So regardless of the size of your company, you need to have some sort of program in place that helps you identify, measure, monitor, and control. And even if you're in a different industry, those same guidelines will apply to you. The other area is your employees, right? So what are your employees saying online? How are they involved in social media? When it comes to the financial industry, there's just so much, regulation around communication specifically. And so if you're looking at your employees, and then when you're looking at your independent brokers and dealers, how are they communicating online? What does their profile represent? What logos are they using? What information do they have in their profile? That slide a little while back that had, that it shows you may have to have their broker number, their broker license number, their home office location, all of that sort of thing. Those all need to be in the social media profile. So how they use social media, obviously, is, promote brand, build relationships, and add a face to the business. That's one area that you have partners that are outside of your parent brand. That's the reason why they exist, really, is to add that face to your brand, because they're likely going to be local. They're going to be dealing with people face-to-face, whether it's an insurance agent or a mortgage broker or a car dealer or whatever. If it's your partner that's out there, their main purpose is to add that face. And so social media does that in a lot of ways. And so by building the brand, building relationships and promoting the brand online, they're doing what any good salesperson is doing, but they can run the risk of these different areas. And I've kind of broken them up in a compliance, reputational, and operational. And we've obviously hit a lot on all the compliance. And even that, I'm just taking the 10,000-foot view. There's a lot that goes into compliance for social media in particular. But that aside, you also run the reputational risk of, brand identity online. If somebody is using your brand to create social media profiles that look like a representative of your company, whether or not they are, that opens up the door to a lot of, customer confusion, for example, customer complaints. And again, we talked about employee use of social media already with respect to reputational risk. And then there's always operational risk of, somebody taking over your account or having some kind of a data breach or that sort of a thing. So, this just gets back to the fact that if you don't have a plan in place, you need to put a plan in place to manage your risks on social media. Can spam. So this is an interesting area because nobody likes getting spam messages, and they created this law, Can Spam, a while back to address that. But where it kind of plays in with respect to your partners is that if they're sending commercial messages on your behalf, you can be responsible for them, even if you don't know about them. And so the law makes it clear that you really can't contract your way out of the legal responsibility. So if you hire a third party, let's say, to send emails on your behalf, whether that's your own partners or whether it's a third-party company that specifically sends email messages, if they're not complying with Can Spam, you could be on the hook for $16,000 per email, which is huge, and a lot of companies have had that issue. So I put this here, just some easy ways to violate Can Spam. If you have misleading header information, if you're saying you're somebody you're not, then that's obviously an issue. Misleading subject lines in order to get people to click and open up the email. Not disclosing the messages as an ad. A lot of times you have to have the words advertisement or this is an advertisement in the message. The other two are usually at the bottom of an email message. If there's no opt-out information, if you can't opt out of that email, then you're going to fall under this Can Spam compliance situation, and then no physical address. So from a perspective of your brokers and dealers and franchisees, if they're sending out messages, you want to know what they're sending out. And so if your compliance team needs to approve them first, which isn't always the easiest way, but either way, you've got to stay on top of it. There are, I hesitate to put this in the presentation because a lot of times with webinars, you're trying to promote your own products and that sort of thing, but canned spam is one of those things that it's just important that you do regardless of how you do it. So, copyrights and trademarks. So this I just have as a bonus because what it is there's a risk for essentially your errors and omissions, your brand, customer confusion. There's lost revenue associated with trademarks and copyrights and how they're used online. If you have a network out there that's using your brand in any way, you need to be on top of how they're using it. If they're using an old logo, that's a problem because you're creating essentially a dual branding situation where some customers will see the new logo, some will see the old logo. They won't know really which is legitimate. They may walk away, go to a different company. So just from a compliance standpoint and looking at your partners, you want to look across the internet at the different areas where they're putting up your brand. So whether that's websites, we'll talk a little bit more about this in a couple more slides, but whether that's your brand on a website that they've created, whether it's an email message, whether it's social media, you want to make sure that they're using your brand assets correctly. Okay. So some corrective action. Just threw this out here, from the CFPB, recent action that they've taken, $250,000 for one company for deceiving borrowers about claims for government affiliation. Another company paid $1 million in civil money because they were deceiving customers about free checking, for example. And then a third on here had to refund $2.9 million. Again, I think I've got them a little bit confused here. So the $2.9 million is the free checking. The $2 million was for referrals and kickbacks. So, there are definite fines associated with your actions and the actions of your affiliates and partners. And so if they're out there doing things that violate a lot of the compliance areas that we just discussed, then you're on the hook for any number of fines and punitive damages. Okay. So now let's go into some details of best practices about what a robust partner compliance program looks like. One that will help you find and address those agents and brokers that may be falling through the cracks today. This is really kind of my area of expertise just in terms of from a partner compliance standpoint online and how you can design a program that looks across channels and brings in all the data that you need in order to make those business decisions. So I always like the high-level overview first. And so this is really, if you're looking at a program, you want to have three main areas, right? You want to have visibility. You want to have visibility into what people are doing, whether those are your partners, whether they're your employees, whatever they are, you want to get that visibility. And with the internet being as vast as it is, I'll talk about you need some sort of a technology solution to look at those data points. Pull in all those social media profiles, pull in those rogue websites or those ads that they're putting on Google and Bing. Without it, you're going to be in trouble. You need to have some kind of visibility. The next piece is always education, because if you educate your third-party partners, whether they're your brokers, your dealers, franchisees, then you're just going to have less problems overall. If when you saw that dry spaghetti map of all of the different government agencies, that takes into account all of the different regulations that are out there relating to those agencies and the industries, and that's what your compliance team is on top of. And so they need to find an effective way to communicate that to all of the, in a way, the laypersons, the salespeople that are out there promoting your brand and trying to get business. So that's the education piece. And then enforcement. You've got to have some way to escalate your enforcement from, a basic, let's assume that this broker doesn't know about this rule, all the way up to, uh-oh, this guy is really doing bad stuff and we need to shut him down. So you need to have a plan in place that kind of takes into account that whole spectrum and it implements it in a very thoughtful and step-by-step method. Okay, technology. So obviously we're a technology company, so we're going to recommend technology. But even that aside, it makes sense because if you're trying to do manually go out across the internet and look for the different types of abuse, and we run into this all the time with folks that we talk to, prospects and that sort of thing, that their current plan is really they go out to Google and they look for their brand, or they go out to you know, it wouldn't really apply to this industry, but maybe eBay, and they're looking for different types of products manually. You know, the internet now has become so localized as well that if you're searching for something from, let's say, San Francisco, it's going to be a different result if you're searching from Chicago, if you're searching from London even, obviously. And so you've got to take into account the fact that if you're trying to do this manually and pull in all these different data points, you're just simply going to be missing stuff. And when it comes to compliance and when it comes to the different financial penalties that can be imposed on you, you don't want to be doing this manually. So, you know, whether it's, you know, our solution or somebody else's, you just have to use some sort of technology. So looking across channels, you know, I've got this little graphic here. It's kind of one we use frequently, and so they all might not apply. In fact, I don't think marketplaces really apply in this situation. But when you're looking for brokers and dealers and franchisees, et cetera, that are out there doing things that they're not supposed to, you know, you want to make sure you cover these different areas. And on the left side, I have some you know, topics, I guess, of what you should be looking for specifically. So, you know, you want to be able to pull in domain name registration. So if somebody's using your brand and they're registering your domain, they very well could be that new insurance agent that you just signed up in, you know, Chicago, for example, or whatever. They could be very, very enthusiastic and be building a whole website empire that you don't know about. And that gets you to that risk threshold area of, okay, they're putting up all these websites and they're not using the correct disclaimers, they're not using the correct disclosures. If you don't know about it, then it's a risk for you. The deceptive advertising, false claims, you know, that's connected with websites that people put up. It's also connected to their social media posts. You know, it could be that they're putting up ads. For example, they're running their own paid search ads on Google or Bing. You don't know where it is unless you find it, and that's one of those risk areas. And you know, you can kind of go down the list: missing, incorrect disclosures. Same thing. If you've got websites that are up and you don't know what's on them, that's a problem. I covered search engine advertising, social media profiles, and then into non-compliant email campaigns. You know, all of these are just, you kind of think of them like areas of data points, and you want to know that 98% of your agents and brokers are out there doing what they should, but there's another 2% that isn't, and maybe they need a slap on the wrist, or maybe they need to be, you know, removed from your program entirely. So you can make that call when you have that visibility. So in addition to technology, I wanted to also throw some other areas out there. So, you know, we've covered the fact that you want to utilize technology across all different internet channels. There are other things you can do as well. So you can have a hotline on your home page that customers can call or email if you have an email, essentially kind of reporting on your own brokers and dealers. This is common in other industries, because if somebody's interacting with a broker or dealer and they're not, and then something's fishy or they just don't feel right about it, then they can call up that number and they can say, hey, you know, this guy told me this, is this correct? So having some way that a consumer can report those is important, because then it helps you find the folks out there that are not behaving as they should. The third point, there are complaint apps and complaint sites. So this is something fairly new. There are actually apps out there that allow customers to, or customers, just anybody really, to write up a complaint about a particular company. And then when you are, when you're a consumer and you're looking for those companies, you can look at these complaint apps and see, oh, this company had this many. I think of it more as like a data mining thing that you can go to and you can look and see where are all the complaints coming in for your business. If they're around a particular agent or broker, then that gives you that red flag that you can then start looking into it more. I don't have it on this slide, but the CFPB has a database of, I think it's 632,000 complaints today that are sortable by company name. They're sortable by location as well. And you can go in there and you can start looking and seeing where these different complaints are coming in that relate to your company in case there's anything there that you can use. Now, again, if you find individual brokers or dealers that are causing a problem, you want to monitor them. You want to look at what they're talking, how they're communicating with customers, what they're putting out there. And then you want to audit the marketing material regularly. So these are obviously, when you start looking at marketing material, I know a lot of company compliance teams will specifically put out specific marketing material that has been vetted and approved. What I'm talking about here is the other marketing material, anything else that these guys are putting out there that may not have gone through the proper channels. So that's just something to kind of keep your eye on there. So now let's talk a little bit about education. I like this quote. This is from an attorney. This is actually from another industry, but companies should never expect their salespeople to immediately know what to do. They need to be taught. Solid education creates an expectation in the field and leads to a more professional sales culture. So you likely have a compliance team that is responsible for educating your brokers and dealers. And, the only thing that I can really add to that is to just make sure that you cover all of the different risk areas that we've talked about today. Because if you have any gaps, that's where your risk is going to be. And I even threw on here the copyright trademark misuse check mark, because that's just another area of risk. It's another area of importance, even though it may not tie directly to government regulators. So now let's talk a little bit about enforcement. This is your enforcement escalation triangle. There's supposed to be another white line there. I don't know why it disappeared, but you want to have some sort of escalation strategy, because these are your partners. When you talk about an agent or a broker that signed up with you, they're excited about your brand. They're out there. They're trying to make you money. You can't come in heavy-handed. I'll caveat that and say, obviously, if they're doing something, fraudulent or obviously illegal, that's a different story. But what I'm talking about are the misuse of, disclosures or not having certain things on social media profiles. So you start off at the lowest level. You want to communicate with them. You want to open those channels. You want to show them specific examples. Okay, this is what we found. This is what our rule book says, or this is what the regulations say. Can you please correct this? And then you follow up. You need to have a team in place that can do that. If that's not completed, then you move up the escalation triangle. You start looking at, okay, now we need to talk to this person. We need to talk to their their territory leader, whatever it is. We need to get some action on this issue. Even if it's a relatively small issue, it still should move up the escalation chain if no action has been taken. And then lastly, you always have the option, depending on what your business model is, what your industry is, withholding commissions, punitive actions, removing that person from your business. You obviously in your own company will have different actions that you can take, but ultimately you have to be able to wield the ultimate hammer and protect your assets and protect your company from risk. So, kind of wrapping up here, I wanted to just put out another area that could be risk, or I guess in the enforcement category. If you're looking at former employees or terminated employees or former partners, whatever they are, so folks that kind of they're not under your umbrella any longer, but maybe they still have your brand assets out there in the wild, and maybe they're using them, maybe they're using them improperly. There are obviously some different things that you can leverage here that I just wanted to put on here, because these are a lot of things that we use at MarkMonitor going after non-affiliated entities. So for example, your counterfeiter or your fraudulent actor. So C&D letters, always a good start. You can go to the ISP if it's a domain. Perhaps you can get some action there. DMCA notices is for copyright. If there's any kind of copyrighted material, you may be able to get some action there. If it's a social media situation, there are different takedowns that you can use for taking down profiles or removing content in that way. UDRP is in the domain world is a way to get domains that are being used improperly. So that can always be an option if whatever it is that you're experiencing falls under that. And then obviously litigation is always an option. So, just kind of talking through some different things. These are not things you would necessarily use on your partners, though. Your partners, you would communicate internally. You would handle the enforcement internally. So, wrap up here. Financial regulation is complex, and it covers multiple agencies. And there are real penalties for not following the rules, as we saw. So you have to have, a plan in place on how you're going to manage all of your independent brokers and agents and franchisees, who report into your parent brand because they're out there using your logos, trademarks. They're representing your brand in the wild. So they're going to be out there all over the internet, and you need to find them. And then you need to have an approach in order to remediate the situation. So that's your monitoring, your education, and your enforcement. So I think with that, if you put those in place, you should be dramatically reducing your risk and hopefully saving the company quite a bit of money. So that's, I think that's the last. Yep, I think we're ready for any Q&A we have.
Great, thanks, Dan. We did have some questions come in. Just as a reminder, if you do have questions, submit them using the Q&A tab. So the first question, what can you do about social media profiles of insurance agents? Can you help remove them?
So I would say no. I mean, you can't necessarily remove them from a social media angle. But what you can do, and this is in a lot of cases with when it comes to partner compliance, is that you can contact them and start working within the channels that they operate in. So, whoever their territory manager is and that sort of a thing. So you need to make sure that they have the right elements on their social media profile, per your industry, per the law, but then to handle it internally.
Okay. The next question, how can we use the CFPB data you mentioned?
Okay. So what they have is they have this database. The database is a collection of essentially consumer complaints, and they have an area they call narratives. And what these are the actual customer complaints in their own words. And so the way that I would use that is I would use that to harvest or to collect data on what is going on out there. You can sort it by company. You can look at your individual company and then even look at location. So if you're concerned about a certain territory or a certain area, you can look at that. another area that actually just kind of came to mind that you might be able to use is like the Better Business Bureau. There may be some elements there, and that kind of goes under that whole complaint app, complaint site, umbrella, where you are then taking the action to go find the complaints before, they start hitting government regulators who are also obviously looking, and before they take action. So.
Great. Next question. Does can spam apply if you didn't send the email message? What if you don't even know about it?
Yeah, from my research, it doesn't matter. So if they're advertising, promoting your brand, and they are in some way connected with you, then you're on the hook for those messages. And it actually kind of gets complicated with respect to the sender and I don't know if it's beneficiary or something, but there are some elements there that you can look at from a compliance standpoint. But the main point there is to just make sure that you are aware of who is sending email messages on your behalf.
Thanks, Dan. So I think we have time for one more question. How can you put disclaimers on tweets or other social media?
So, okay. That's kind of a tricky one. Obviously with the large disclaimers that a lot of these agencies recommend, there's no room in a tweet, right? 140 characters. That .com disclosure guide from the FTC is a good one to look at. I believe, like what they'll do is they suggest #ad. So if you're an agent and you're putting up essentially what is an advertisement, they want you to hashtag it as an ad so that people know that it's an ad. And then the other piece of that would be to make sure that the social media profile has all of the information that's required, like the license number, location, etc., so that they can then click through and say, oh, okay, this is this person that's putting up this social media post, and so then they know that it's potentially an advertisement. So take a look at that .com disclosure guide. That'll have a lot more specific information.